Welcome, everybody. I am Javier Rivera Carbone, workplace investigator, employment attorney, and I'm here for the Labor and Employment Law section of the Orange County Bar Association case update for the month of March of 2025. I would like to introduce our presenters today. First, Adrienne De Castro. She concentrates her practice on advocating for workers in wage and hour, class actions, and PAGA litigation. She's a senior associate at the Sci Law PC. Adrienne is an active leader in the legal community and is a professor at the University of California, Irvine School of Law. Arcelia Magaña concentrates her practice on advising and defending businesses in employment law matters. She's a senior counsel at Constangy Brooks Smith and Profet LLP. She's very active, a leader in the legal community, and a past president of the San Diego La Raza Lawyers. Adrienne, Arcelia, please go ahead.
Thank you, Javier. So I'm here just to go take a deep dive into one of the cases from our March updates. That case is Perez versus Rose Hill Company, a case out of the Ninth Circuit. The basic facts here that plaintiff is a formerly hourly employee for defendant Rose Hill's company. She files a wage and hour class action alleging overtime violations, meal and rest break violations, and a failure to pay for all regular hours. As is fairly typical, the plaintiff here did not specify in the complaint the amount in controversy. Rather, the complaint generally stated that the violations occurred at times during the statutory period, which is 4 years prior to when the complaint was filed. The defendant then sought removal under CAFA, claiming that the amount in controversy was approximately $15 million, well above the CAFA jurisdictional amount. In support of its removal, the defendant submitted an attorney declaration establishing a class size of approximately 759 class members, and the company interpreted the at times language to mean every week during that class period that it failed to pay class members for 1 hour of regular time, 1 hour of overtime, and 1 hour of a compensable meal break and 1 hour compensable rest break. It used the minimum wage during that statutory period and estimated an approximate 33% attorney fee award. So in sum, the defendant used only the complaint and the attorney declaration to establish the class size. The district court denied the removal and remanded on its own motion, stating that the defendant was required to produce evidence for its estimate as to the amount in controversy, and that it had no basis for suggesting the particular violation rate. Goes up to the Ninth Circuit, and the Ninth Circuit vacated and remanding, stating that the district court should have looked at whether the violation rate that the defendant assumed was, quote, a reasonable interpretation of the complaint. The Ninth Circuit stated that the district court erred by simply rejecting the defendant's assumption as, quote, not supported by evidence. The Ninth Circuit stated that evidence is not required to support violation rate assumptions, particularly since most defendants will assume no violations if they could have it their way. So even though the complaint's language could support either a higher or a lower violation rate, so long as it was a reasonable interpretation, that's the standard that the district court should have used on the remand motion. The court may consider evidence, but it may also consider reasonable assumptions. What are the key takeaways from this case? To obtain CAFA removal as to the amount in controversy, a defendant may rely on a reasonable interpretation of the complaint. Evidence is not required to determine a violation rate, which makes sense given that it's fairly early in the litigation. The reasonableness in this case of the defendant's interpretation was likely bolstered by the defendant submitting even lower calculations as to the violation rate, dropping it 50%. And even in that instance, the $6 million would still meet the CAFA jurisdiction amount. As a plaintiff's lawyer, I would suggest that if you have an estimate of the violation rate, you can include that in your allegations in the complaint. Or basic info that may allow you to, at least from the allegation, state that CAFA jurisdiction is improper. In the absence of this information, I don't think it's the end of the world if you get removed from state court. What I've done in the past is I use the information that the defendant has submitted in that removal motion to support a damages calculation at mediation. That it's not it's not the end of the world if you get removed, and that information can later be useful to you in your damage calculations. I'll pass it on to Arcelia if she'd like to offer some defense perspective on this case.
Yeah, thank you, Adrienne. So from a defense perspective, I'd say this case is pretty good. It is worth reiterating that defendant's interpretation of the amount in controversy is valid if it aligns with the complaint's language, even if other rates are equally plausible. So practically speaking, in removing these kinds of cases, defendants should tether assumptions to complaint language, reviewing the complaint carefully for the general phrases like at times or throughout the statutory period, and capitalizing on the ambiguity. Also use conservative estimates to demonstrate reasonableness, and use declarations for objective data like class size and wage rates, but not necessarily for violation rates because, as was mentioned, we're still pretty early on in litigation. Tying it all together by arguing that plaintiff's vague complaint justifies a broader amount in controversy assumption. So the next case that we want to highlight for you all is Melissa Mendel Brown versus Novo Nordisk Inc., coming out of the Second District Court of Appeal. Plaintiff in the underlying case filed a complaint against defendant, asserting 16 causes of action, including FEHA and wrongful termination claims. Defendant filed a detailed motion for summary judgment that included 161 undisputed facts, 7 declarations, and over 70 exhibits. 2 days before the MSJ hearing, plaintiff, who had not filed an opposition, undoubtedly had an uh-oh moment and applied ex parte for a continuance of the hearing and trial, which was granted, delaying both dates for a little over a month. Then, like Groundhog Day, 2 days before the new MSJ hearing date, plaintiff, who had again not yet filed an opposition, applied ex parte for another continuance of the hearing and trial, which was again granted, delaying the dates for another month. The MSJ hearing date came around and plaintiff still had not filed an opposition. But not only that, plaintiff did not try to request another continuance, and plaintiff didn't even show up at the hearing. Yikes. The trial court then granted defendants MSJ based on the fact that no opposition had been filed. In doing so, the court relied on CCP 437C subsection B3's requirement on a separate statement in opposition. The code section also gives the court discretion to grant the motion if an opposing separate statement is not submitted. Plaintiff appealed, and to no one's surprise, the Court of Appeal affirmed the trial court's ruling, reiterating that while MSJs are generally reviewed de novo on appeal, when the trial court's decision is based on a party's failure to comply with the separate statement requirement, that is reviewed under an abuse of discretion standard. The court determined that the code is pretty clear on this issue, and given that defendant's motion was not defective on its face, there was no abuse of discretion. Plaintiff did try to argue that the trial court was required to review the evidence and make a determination as to whether defendants had met their burden, instead of ruling on more procedural grounds. However, in a footnote, the court stated that it disagreed with plaintiff and decisions like Thatcher v. Lucky Stores to the extent they mandate that a trial court conduct a prima facie review of the moving party's evidence despite the absence of an opposing separate statement. The court did note, however, that its ruling was limited to this scenario, where defendant files an MSJ and plaintiff fails to file a separate statement, and expressed no opinion as to the scope of the trial court's discretion if it had been plaintiff's MSJ and defendant's failure to submit an opposition. This leaves open the possibility that had the rules been reversed and had it been plaintiff's MSJ, instead of granting the motion on the basis of no opposition, the argument that the court should have reviewed the motion on the merits, regardless of a submission of an opposing statement, might have carried more weight. Moral of the story, pay attention to deadlines and procedural requirements and oppose MSJs, especially if you're the plaintiff. Adrian, what are your thoughts?
I couldn't agree more. I read the case trying to figure out what happened and why the plaintiff didn't file a separate statement, but I couldn't find that information. And as Arcelia pointed out, this should be a cautionary tale before you file a case, particularly in a court that you may not be familiar with. Look at the local rules, look at the court's specific rules about how you're supposed to file motions, because they, while they may seem, picky for that particular court, not so much the separate statement, but other rules that may apply, the court likely has a reason as to why they want the parties to file things a certain way. In this case, a separate statement allows the court to more efficiently analyze the issues, and particularly in this case that was complex. So follow the rules, look at the local rules, be overly cautious if you have to about ensuring that you're meeting the requirements that the court sets forth. And I think I'm left to do one other case here, and Arcelia will follow with her short summary of a case, Johnson versus Department of Transportation, a case decided in March 2025. I'll just briefly say this is about what is the scope of the application of the attorney-client privilege. As you may have read in the case update, here, after the plaintiff sued, the defendant contacted a supervisor to gather information. The supervisor forwarded the email from defense counsel to the plaintiff. Plaintiff then forwarded it to his lawyers. The lawyers then forwarded it to his experts. The defendant sought and obtained a protective order to halt the use of this email. And the court later disqualified the plaintiff's lawyers for continuing to use that email. Again, another cautionary tale. Even with accidental or purposeful disclosure, the privilege cannot be waived by a supervisor without the client's consent. This case makes clear. And from a practitioner perspective, I would advise ever using information that is potentially protected attorney-client privilege or attorney work product. Make it a practice to immediately turn it over, because no email, no information is worth risking your credibility with the court and with the bar.
100% agree with that. Another honorable mention for one last case, Sexton versus Apple Stores LLC, which is a case involving workplace safety and public health and stems from COVID-19. In this one, actor Brent Sexton sued Apple Studios after they pulled him from the role of Andrew Johnson in Manhunt when he refused to follow their COVID-19 vaccine policy, claiming medical reasons. The California Court of Appeal sided with Apple, using the anti-SLAPP statute to toss out Sexton's discrimination claims. Apple's mandate addressed public health and historical discourse / creative liberties, use of Andrew Johnson's history. And the court found that it was a reasonable safety measure in a collaborative work setting and emphasized that employers can enforce such rules even over individual objections, particularly when public safety is at stake, and especially here in California. This case shows that courts may uphold employer health mandates, especially in industries where close contact is the norm. It also highlights how anti-SLAPP protections can cover workplace policies tied to broader public concerns, reinforcing the balance between safety and personal rights. And with that, I will turn it back over to Javier. Thank you, everyone.
Thank you, Adrian. Thank you, Arcelia. Thank you for your insights. And also thank you to the law firm of Payne and Fears who prepared the summaries. You received the summaries with the email that you received the link to this presentation. Also, we would like to invite you to our next in-person meeting on May 6, 2025, together with the workers' compensation section of the Orange County Bar Association on the subject of collaboration between employment lawyers and workers' comp lawyers. Please register going to ocbar.org. And with that, we thank you for your participation and for listening and watching this presentation. Thank you.